ये अनफेयर ट्रेड प्रैक्टिस कैसे मतलब सीसीआई में नहीं है?
सी अनफेयर ट्रेड प्रैक्टिसेस का एक पूरा चैप्टर होता था। एमआरटीपी एक्ट के अंदर 3 तरह की प्रैक्टिस होती थी। एक एमटीपी मोनोपोलिस्टिक ट्रेड प्रैक्टिसेस, उसका एक अलग सेक्शन था। देन रिस्ट्रिक्टिव ट्रेड प्रैक्टिसेस, उसका एक अलग चैप्टर था। एंड अनफेयर ट्रेड प्रैक्टिसेस लाइक मिसलीडिंग एडवर्टीजमेंट एटसेट्रा, उसका एक अलग चैप्टर था। अभी एमआरटीपी एक्ट में हमारे पास 3 ही ऑपरेटिंग सेक्शंस हैं। एक एंटी कॉम्पिटिटिव एग्रीमेंट, सेकंड अब्यूज ऑफ डोमिनेंट पोजीशन एंड थर्ड कॉम्बिनेशन। तो इन तीनों में कहाँ है आपके पास मिसलीडिंग एडवर्टीजमेंट और उससे रिलेटेड कोई प्रोविजन है आपके पास?
ओके सर।
ठीक है। अभी जो ये अनफेयर ट्रेड प्रैक्टिसेस जो हमने पीछे पढ़ा था, जो मिसलीडिंग एडवर्टीजमेंट, होर्डिंग एटसेट्रा से रिलेटेड होती है, that is the part of the Consumer Protection Act because that directly affect the consumers. So वहां पे है, यहाँ पे हमारे पास कंपटीशन एक्ट में नहीं होता है। नेक्स्ट इज that under MRTP Act there was no regulation related to combination. Combination means merger, acquisition or takeover. But under the Competition Act we have section 5 6, section 5 and 6. Section 5 define combination and threshold limit. Every combination inquiry will not conducted. Only those combinations that is above than the threshold limit. Threshold limit as per section 5, a limit is prescribed. If the enterprises are going to combine whose total that market value is this or the turnover is this, so that threshold is provided. Above than threshold only the enterprises inquiry will be conducted, and only those enterprises also have to give the notice. Otherwise there is no need to give the notice, there is no inquiry will happen. So there is under the MRTP Act there was no regulation related to combination. Under the Competition Act there are specific provisions that uh, talk about the regulation of the combination. There is the special provision with respect to the procedure of the inquiry into the combination. Section 20, section 29, section 30 and section 31 are related to it. Then next point of difference, that under MRTP Act there was no advocacy provision. MRTP Commission was not having any advocacy provision where the MRTP Commission can, organize the training, can disseminate the information, can organize the conferences, symposium, can, promote the research and all those things. But under the Competition Act, we have the specific provision, section 49, that talk about the advocacy role of the CCI. Under the MRTP Act, the focus was on size of the enterprise. The third chapter of the MRTP Act was, and that was targeted to concentration of the wealth. कि आपकी इंटरप्राइज की क्या साइज है, that was the focus. But here the focus is on the not the size of the enterprise, but what is the conduct of the enterprise. If only 3 things are prohibited under the Competition Act, only 3 market behavior are termed as the, you can say, hit by the Competition Act. One is anti-competitive agreement. Second is abuse of dominant position, section 4. And the third one is combination. So the focus under the Competition Act is on the conduct, not on the strength or the size of the enterprise. Okay. Now the next difference between MRTP Act and Competition Act is that under MRTP Act the approach was procedure. It was procedure oriented. Procedure बहुत ज़्यादा था. Suppose there is a restrictive trade practice. So before entering into the agreement, you have to register that agreement. कि जाके ऑफिस में रजिस्टर करवाओ इस एग्रीमेंट को, but there is no such result. So here under the Competition Act, the approach is result oriented. Under the MRTP Act, the approach was procedure oriented. कि प्रोसीजर पूरा फॉलो होना चाहिए. And under the Competition Act, it is result oriented approach. Under the MRTP Act, the behavior was in reformist, that if it is a big enterprise, divide it before getting the establishment, permission has to be taken. So reformist approach was there. But under the Competition Act, punitive approach is there. Punitive, that these are the conduct. If the enterprises will commit these conduct, then this is the consequences you have to face. Okay. Then the last difference you can write, that under the MRTP Act, that offenses are implicit and were not properly defined. But here under the Competition Act, we have a full chapter related to penalty, section 42 onward, and offenses are clearly and explicitly defined. So these are the differences between the MRTP Act and Competition Act. Maybe this question be also, if it is asked, it can be asked only in the 10 point. So till date, we have discussed that basic understanding of the competition, where we discuss why we need competition, how the what is the economic rationale of the competition, how the competition increase the efficiency. Then the second thing we discuss, the constitutional aspect of elimination of wealth, the constitutional basis of the competition regime in light of the preamble that talk about the economic justice, social, economic, and political. So it talk about economic justice also. Then in light of Article 39B and 39C, and also the fundamental right, Article 14, 19, and 21. Because indirectly you can say that under Article 19, every person has right to profession, and that profession should not be disturbed. A person should get the opportunity by complying with Article 14 also. Article 14, 19, and 21 is known as the golden triangle of the fundamental right, and it's important for the protection of the fundamental right. Okay. Now, the next thing we have discussed, and that on the 20 marks can be asked, was the history and development of competition law. And on this question, you have to start from very beginning, from the ancient time till the date, that how the competition law, what are the different phases where we finally reach at this particular regime. You have to start that in ancient time, what was the oldest piece, then how it was started from America, enacted the law, Ceremon Act. Then in India, when we got independence, there was the in 1948 there was a policy. Then in 1951 there was the act. Then was Hazari Committee. After that, there was a Monopolies Inquiry Commission that gave the report. On that report, MRTP Act was enacted. Then MRTP Act was reviewed, and it was in 1977. Such committee gave some recommendation. Uh, for implementing those recommendation in 1984, Amendment Act was brought. Then India reform its economic reform brought the liberalization, privatization, and globalization. And to meet the demand of that economic reform in 1991, the another amendment in the MRTP Act was happened. After that, in 1999, the next development was that the finance minister in the budget session has talked that we constitute a commission, high powered commission on competition policy and law, that is Raghavan commission. The Raghavan commission then gave the recommendation, and then the Competition Act 2002 was passed. So this is pre-development, यानी एक्ट से पहले का क्या कैसे कैसे डेवलपमेंट, कैसे कैसे सिचुएशन यहाँ तक पहुंची जिसके कारण कंपटीशन एक्ट पास हुआ. And at the international level also you have to discuss that India was one of the member of the WTO. Then WTO entered into the uh, GATT and TRIPS, and to comply with that also India required some comprehensive legislation. Then there was the post enactment development, where that when act just enacted, there was the writ petition in by the Brahmadat versus Union of India, that the government through the parliamentary law has created such authority CCI that have both executive functions also and quasi judicial function also. There was no separation of the power, and on that the central government have given the promise. Affidavit has been filed, and the Supreme Court has dismissed the, dispose the appeal by giving the direction. And to making those changes, the central government come up with the 2007 amendment. After 2007 amendment, there was the 2012 amendment bill that talk about group dominance, but that bill was not passed. After that, in 2017, the another amendment act was brought, and the competition appellate tribunal, then converted into the appellate tribunal. And the national companies appellate tribunal, and NCAL, was constituted under section 410 of the Companies Act 2013, was given the jurisdiction to even look into the appeals arising from different sections under section 53 capital A. So these are the post-independent development. So this big question may be asked. Now this half portion remain, because today our space was very less. धीरे धीरे हम पढ़ा रहे थे तो समय लग गया. Now the second portion here is that what is the constitution of the establishment and constitution of CCI. Section 7, Section 8, Section 9, and then Director General, Section 17, appointment of Director General. Then you have to see Section 41, duties of the Director General, and Section 18, duties of the CCI. So Competition Commission की establishment, उसकी composition, उसकी power, उसके function, उसका jurisdiction, एक aspect. Second aspect, Director General of Investigation, that is the the investigating wing of the CCI, उसकी power, उसकी functioning, and how the penalty and enforcement. And on this there will be two cases. So the CCI versus Steel Authority of India Limited and Mahindra Electric Mobility case. So these two cases. So in the next class we will discuss this portion, and after that this first topic will over. So with this I stop here. If you have any specific question you may ask. Any question?
So can you summarize why you said the CCI introduced for economic stability? I couldn't understand that point.
What?
CCI was introduced for economic stability. You said some words in between lines, so I couldn't miss that. I couldn't get it. Why it was introduced?
CCI was constituted under the Competition Act to establish the, you can say, to prevent some practices that disturb the competition, to make an competitive environment in the market, so that every enterprises will give its optimal results, and that will benefit the society at the large. Okay.
Okay, sir.
Okay guys, any other question?
सर MRTP का पॉइंट नंबर 1 जो था बिहेवियर वाज द फॉर्मिस्ट, और इसमें डिवीजन की कुछ बात हुई थी.
देखो एमआरटीपी जो था उसका बिहेवियर वो रिफॉर्मिस्ट अप्रोच था, लाइक इफ देर इज द बिग एंटरप्राइज उसका डिवीजन कर दो, ठीक है, तो वहां पे रिफॉर्मिस्ट था, या उसमें रजिस्टर करना पड़ेगा अब इस तरह की ये एग्रीमेंट है, टाइन एग्रीमेंट, रिफ्यूजल टू डील, एक्सक्लूसिव सप्लाई एटसेट्रा. If there are these agreement, then the enterprises has to register that agreement. But here the approach is not there. Approach is simple, like you have in the other statute, that if this is the prohibited activity, if someone will do, then this is the consequence, this is the result. So that's the different approach here.
डिवीजन तो सर सेक्शन 28 में डिवीजन की बात तो कंपटीशन लॉ में भी है सर.
But that is only after you found that the enterprises did the preventive some prohibited act only. So that is the form of the consequence. If you did some act that is prohibited, so as a consequence the punitive approach is there. Punitive approach is there. It is not preventive approach, it is not reformative approach, it is punitive approach. Okay.
Sir,
Thank you.
okay. Sir,
Okay
CCI.
guys,
Okay, thank you, sir.
bye, good night, bye, see you.
Good night, sir.
Good night, sir.
Thank you,
Yes, sir.
sir.
Good
Good night,
night.
sir.